Today our topic is President Obama's expansion of I-601 waivers of unlawful presence. My name is Carl Shusterman. I'm an ex-INS trial attorney, and I've been practicing immigration law for the last 38 years. And hopefully I will be able to explain this in such a way that you will be able to take advantage of this program. Who's eligible for a 601 waiver? Well, first of all, it applies to you only if you're present in the U.S. and if you're ineligible to adjust your status. Maybe you came in illegally to the U.S., maybe you came in some temporary visa that doesn't allow you to adjust your status, and you need to go abroad, probably back to the embassy in your country to immigrate. And you're going to be separated from family members who are U.S. citizens or permanent residents, and you can't come back for 3 or 10 years because you're subject to bars because you have unlawful presence in the United States. So it's very useful to go over a little bit of the history of the 601A waiver in order to see what benefit it is for you. Before 2013, if you were going abroad to apply for an immigrant visa, you had to file the I-601 abroad, and you might be there for months or even over a year waiting for it to be approved, being separated from your family. President Obama started the I-601A Provisional Waiver program in 2013, but he limited it to immediate relatives only. So that meant you could only apply if you were the parent, spouse, or child of a U.S. citizen. This left a lot of people out in the cold, so in November 2014, the president proposed expanding the waiver program to include sons and daughters, whatever their age or marital status, of U.S. citizens and spouses and sons and daughters of green card holders. Now, not everybody who applies gets the waiver. You must show that your qualifying citizen or green card holding relative would suffer extreme hardship if you were not allowed to return to the U.S. for over 3 or 10 years. Over a third of these waivers are denied. So President Obama has proposed that the definition of extreme hardship be clarified so people who are not eligible don't bother applying. So when do the new rules become effective? Well, not right at once. You have to wait for the USCIS to issue guidelines. You have to wait for regulations. My best guess is sometime before the end of 2015 or sometime in 2016, we'll see regulations and you'll be able to apply. Now, how can you stay updated while you're waiting for the regulations to come out? You can join 60,000 people and subscribe to our free newsletter, because we'll be covering the final rules in the newsletter. You can go on the social media and join us on our Facebook, Twitter, and Google Plus pages, which are updated several times a week. And you can subscribe to our YouTube videos and to our blog.